Imagine you invented a permanent cure for cancer, and then just in less than 1 week, a similar product is all over the markets. What will that mean to you? Welcome to Education, our weekly legal podcast, where we break down legal matters, legal issues, legal topics, and concepts to your understanding without having to go to the law school. This is another episode in our series on intellectual property, and today we are going to be discussing patents. What does it mean? Who does it protect? What's the duration of protection and all? Join with me as I take you through this. Patents is a license that confers the owner the exclusive right to use its invention for a period of time to the exclusion of others. Patent protects inventions, that is, new invention or a new process of doing certain things. I'm not going to bug you with a lot of definitions. I'm just going to try and break it down. All right. Now, imagine you invest about 10-20 years of your life in the laboratory to discover or to invent a drug that can cure all manners of cancer and all. Nobody has done that before. This is novel. This is new. This is a new invention. The law of patent protects that kind of effort just to ensure that you are able to enjoy that exclusivity for a period of time to be able to, of course, recoup your investment of time and even economic investment on that invention. And it also protects, let's say, that the only drug or the only cure available for malaria is through injection and injection alone. Now, due to the hazards and disadvantages of using injections and all, you also decided to find a new process of curing malaria. The same drug, only that this time around you have now made it into a capsule that people can now swallow, or something they can now rub on their body and then will effectively cure the same malaria. That's a new process of doing and hold a thing. That is also protected by patents. A work will not be regarded as an invention if it is merely a discovery. A discovery is different from an invention. A discovery is just that you have found out what is already existing. An invention is that you have created something that does not exist before now. Patent does not cover discoveries. Patent does not cover, musical work, artistic work. We have discussed that under copyright. The right to a patent is vested in the person who files first. Right? This is regarded as the statutory inventor. The person doesn't have to necessarily be the inventor, the original inventor. But if he is the one who files first, he is the statutory owner or is the statutory inventor. But the original owner, that is the original inventor, the original inventor has a right to be named in the patent. I know this right is usually non-negotiable. What's the duration of patent? Patents last from the date of application for that patent. It lasts it protects the owner for a period of 20 years. Within that 20 years, the inventor is expected to be able to cover his economic investment in that product for that time, or from that invention within that time, whether it is drug, whether it is an engineering work, whatever it is, invention, as long as it's an invention that is protected, you have 20 years to be able to get commercial value for your product. I have mentioned the reason why patent is very important. If you invest, there are people who are already working to invent things that will be used in 2050, even as of now. Imagine they invest this period of time, and then by 2050, when that invention comes to play, it's already flooding the market by other manufacturers and all. It means that their years of investment and all will be lost. The economic value will be lost. And that is why patent is very, very important to protect inventors. People who are scientists, people who are in the pharmaceutical industry and all, patent must be your friend. It is important that I point out that just like trademark, patents are also territorial. That is, they are limited to a territory where it is registered. Unlike copyright, that your copyright is protected across the world or in every jurisdiction, for trademark and patent, it is limited to the territory where you register it. It means that if you want your patent to be protected in other countries and all, you will also need to make application in all those places. However, for instance, in Nigeria, because Nigeria belongs to a lot of conventions, international conventions and all, there is the provision for you, if you have made an application in another country that is a member of that convention, if you have made an application and you now make a new application in Nigeria within 12 months of that previous application, you will be given priority based on your the date of your first application. What that means is this: imagine that Ghana belongs to the same convention with Nigeria, maybe like convention like WIPO and all of that. Now, Ghana belongs to the same convention with Nigeria, and you make your patent application in Ghana, maybe in January 2025, and then you come to Nigeria to make the same application in August 2025. We all know that somebody else may have decided to apply for it in Nigeria within the last 1 year, but the patent law will give you the priority because you have made the application first in Ghana before any other person. So your application in Nigeria, even though you are making the application in September 2025, it will be dated back to January 2025. That is permitted under the patent law in Nigeria, and that's to give you some level of protection. This is where we pause today. Thank you for joining us always. If you have any question, any issues, clarification as regards patents or any of our previous videos, do well to drop your question in the comment section. We will definitely get back to you. Once again, thank you for always joining us. Ensure you subscribe, ensure you like, share, and drop a comment. Thank you.